How to close your business safely and legally. DIY step by step. Many reasons may compel an owner to close down a business. Maybe he or she isn't making it financially, has decided to move on to the next big thing, or no longer has the time or will to manage the business. Whatever the reason, a business owner, that is, you, if you are in this situation, can close down the company safely and legally by following these 10 steps. Welcome back, folks, to another edition of Sweetie Kiwi. How you doing today? I'm doing fantastic. If you were to ask me, if you are doing as great as I am, go grab a cup of coffee or tea or vodka and let's roll. Today I want to talk to you about how to close your business safely and legally, and I'm giving you a DIY step by step. Before we get into the nitty-gritty, let me first give us a disclaimer here. This show is not about giving you guys legal guidance or legal expertise or legal advice. We're not lawyers, we're not attorneys. We have done considerable research, we have done thorough research, read a lot of legal literature to bring you this show. However, your particular situation might require the help of a licensed, of a professional attorney. If that's the case, please reach out to someone who can help you. However, having said that, this is a DIY step. In other words, you can follow this and do it yourself if you have the will and the time for it. Okay? All right. Number one, determine if you can DIY the business closure. That's the very first step here. Whatever your reasons for closing your business, there are a few legal tasks you need to undertake to protect yourself, your credit, and your reputation in the community, especially if you ever want to go into business again, right? So here are the main steps you'll need to take to shut your business down legally and minimize the risk to your personal asset. Now, you have to vote to close the business. You have to dissolve your business with the government. You got to cancel permits, licenses, and fictitious business names, those DBAs, doing business as. You got to pay your taxes and debts. You got to notify your creditors, employers, and customers. And you got to follow up on some kind of other paperwork, including AR, accounts receivable, contracts, and regulatory agreements. Now, this is something you got to think about. Is it something you want to do? Can you do it yourself? Do you have the time? Do you have the will? Do you have the intellectual capacity? Even though this tutorial is DIY, you still need to have some basics to be able to do that yourself. Now, if you don't have the time or will, hire an attorney. Step 2, you need to vote to close the business. If you have been operating as a sole proprietor, you simply make the decision on your own or with your spouse, and you can just skip it to the next step. But if you have been doing business as a corporation, as an LLC, a limited liability company, or partnership, you and your business associates need to agree to dissolve the entity, and you got to follow either the procedures that you set out in the organizational documents or the rules set out in your state's business statutes. Generally, this rule requires at least a majority of the owners to agree on dissolution, but they could require a 2/3, that's 66%, or even unanimous vote. So you want to dig out those documents to make sure you conduct the voting correctly, or check your state's corporation, limited liability company, or partnership statutes to find out what the rules are. You can go to the internet, you can go online, go to your state's department, the state department, to get your state's business statutes. Now, one thing that I want to pay attention to is you need to make sure you record your decision with a resolution in the minutes of a meeting or with a written consent form. This is critical, folks. So once you vote to close the business and you have written the consent form, everything is written down, black and white. This is perfect. You move to the third step. Dissolve your business with state and local government offices. If you've been doing business as a corporation or LLC, you need to officially dissolve your entity so that you are no longer liable for business taxes or filings in your state. Now, officially dissolving your business also puts creditors on notice that your entity can no longer incur business debt. Your state corporation or LLC unit, which is usually a division, a segment, a department of the Secretary of State, should have the necessary form. This form set out the disposition of your business debts and liabilities, the distribution of your business assets, and how you and your co-shareholders or partners, if this is an LP, elected to dissolve your business. LLCs have to file similar documents. Sometimes those are called articles of dissolution. In some states, such as New York, New Jersey, Connecticut, and Arizona, before you will be allowed to formally dissolve your business, you may also be required to obtain a tax clearance or consent to dissolution from your state tax board, declaring that all your business taxes have been paid. The rules and forms for dissolving a business entity, though, are usually posted on your state Secretary of State's website. This has to be a permanent resource for you. If you are thinking about dissolving your business yourself, you want to check every bit of info on your state Secretary of State's website. You may have to look under FAQ for information. If you need to find a link to your Secretary of State website, you need to go to, there is a general platform out there that provides information for all 50 states, and that is www.statelocalgov.net. If you've been doing business as LLC or as a corporation. If you have been doing business as a partnership, you may need to file a dissolution form with the state, particularly if you filed paperwork with the state when you formed your partnership. Right? In some states, the name differs. For example, in California, if you filed a statement of authority with the Secretary of State when you formed your partnership, you must file a certificate of dissolution when you dissolve your partnership. Either way, required or not, it's always a great idea to file a dissolution paperwork if you can, so that your creditors are put on notice that the partnership can no longer incur debts. This is particularly important if you are involved in a general partnership where any partner can usually bind the partnership to a deal, and every partner is personally liable for all business debts. The last thing you want to have is that you have the company one down, the company is closed, and then 2 or 3 weeks later on somebody calls you on the phone, and on the phone you're like, oh wow, Mr. or Mrs. we believe that you owe us $10,000, and you will be thinking, wow, I've never had anything to do with you guys. Well, you have a partner who has a former partner, that is, who has incurred debt, and because of the legal principle, the legal concept of several liability being severely liable, all of you in the partnership have to pay. So you want to avoid that. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweetie Kiwi. I hope you are doing fantastic. We are still continuing on our journey here, and the goal is to show you how to close your business safely and legally. Let's go to step 4. You want to cancel permits, licenses, and fictitious business names. No matter what kind of business you are, you want to cancel any kind of permit or license you hold with the state or county. You don't want anyone else to use your seller's permit or business name, for instance, that could make you responsible for any taxes and penalties incurred after you no longer operate the business. If you have a seller's permit or business licenses, for example, contact the agency that issued the permit or license and cancel it. And the most important thing is you want to receive from them a written confirmation that the license or business or permit has been indeed canceled. If you have let's say you have, if you've been using a fictitious or assumed business name, file something called an abandonment of the name and publish it in a local newspaper. You want to contact your county's clerk's office for a form. Now, a fictitious name is also called DBA. Sometimes you have these things, you can see it. It says DBA means doing business as. All right. You want to notify your creditors, employees, and customers you are going out of business. Those are the critical stakeholders you want to inform. These constituencies will also they will actually pass on the info to other constituencies. When you're going out of business, when you know that it is inevitable, you want to notify the following companies people or constituencies, like I said, of your impending closure. Suppliers, because suppliers will want to know when the last delivery should be made, what goods you're returning, if that's part of your contract, and where and how they'll get paid for goods they've supplied. However, if you're not ready to stop buying, you may want to keep your impending closure quiet for a while, right? This is just strategic. This is smart. Some suppliers, when they find out your business is about to close its doors, may pull your credit line and require that all orders be paid for in cash. And then next, you have the service providers. I'm talking here about providers of utilities, business insurers, payroll preparers. They will want to know the final day you'll require services and where to send the final bill. If you have any deposit down, find out how to get them back, if you can get a refund or something similar. Now, when you notify, let's say you notify your business insurer that you're going out of business, the insurer will want to know for sure about any potential liabilities that might crop up after the business is shut down. The thing here is that always be honest, follow proper business etiquette, because you risk losing coverage if you don't disclose any pending legal threats or problems. Bank accounts and credit cards. Be sure to close out your business bank account and cancel your business credit cards. You don't want anybody to use them and have the company being forced to pay. Lenders, if you have any open business loans, your lender will want to know how you plan on paying them off. The lender may want to take a look at any business collateral to make sure it is in a sellable condition. Landlords, you need to give your landlord the contractually required amount of notice as stated in your lease, and usually is 30 days in most states, and in other states it's 45 to 60 days. If you're closing your business before the end of your lease term, you are liable for any remaining rent payment, although depending on your state's law, really, your landlord might have what's called a duty to mitigate. And they might be it can do that by looking for a new tenant. In any case, your landlord will probably want to work with you rather than chase you down for the money in court. So you may be able to negotiate something. Now, if you're not breaking the lease early and the landlord is in a position where they're holding a deposit from you, be sure to get it back. What about employees? Let's talk about employees, because they are also a quintessential constituency when it comes to closing your business and informing people, right? So if you have employees, tell them what you expect from them until the last day. If you fear a premature mass exodus of employees, tell only key employees of your plans to close, but be sure to give the rest of your employees at least 2 weeks notice. This is the law. Customers, same thing here. You want to give your customers plenty of notice that you are going out of business. Then you fill any last orders, complete any final paperwork, and fulfill any contractual obligations. Now, if you can't complete a project or a contract, let the customer know immediately and return any deposits or payments for goods not delivered or services not rendered, if those clauses are contractual. Now, if you have outstanding accounts receivable, try your best to collect these bills before you notify your customers that you will be closing your doors, because invoices may be much harder to collect on once you're out of business. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweetie Kiwi. Let's just continue our conversation here around how to close your business safely and legally. I'm giving you a DIY step-by-step. But before I go on to the sixth step here, please consider subscribing to our channel and click on the notification bell so you are aware whenever we drop a new show. We do this kind of show every single day, rain or shine. And if you love the content, please like it, share it, and comment below. Let us know your experience when it comes to closing businesses, and whether you have done a DIY yourself before or you have gone through a lawyer. We want to hear the whole 9 yards. Now, let's talk about taxes here. You need to pay your taxes before other debts. This is critical. Employment-related taxes. First and most importantly, if you have employees, make sure your final payroll tax deposit are filed. and you want to file all of your final employment tax paperwork on time. Also, the federal and state employment tax authorities need to know you're going out of business. So the federal unemployment tax return, that's the IRS form 940, and the employer's federal tax return, IRS form 941. These two have a box you can check indicating you will not be filing future tax returns, and your state withholding and wage reporting return should have one as well. Now, if you want to have more info, just go to the IRS, go to the www.irs.gov, and you go to other forms and publications. Beware though that the IRS, the Internal Revenue Service, can hold you and any co-owners personally liable for payroll taxes, even if your business operated as a corporation or LLC. That's just the government. The government has this advantage; they can change the rules. This means the IRS could take your personal assets, such as a car or a vacation house, to pay your business debts. Filing bankruptcy is of limited help in this area. So your only options may be to negotiate a payment plan with the IRS and see how you can pay things over, say, 6 months or 9 months or 12 months. And you can get the IRS to accept a settlement. And this is usually called an OIC. That's called an offer in compromise. So now you have the asset sales. So you have employment related taxes, you have asset sales. If you'll be selling off some business assets to recoup some of your investments, you'll need to file form 4797, sales of business property. Now, if you're selling all of your business assets as a group, you may need to file form 8594, not 8594. It's called asset acquisition statement. For more information, again, you can go to the IRS website, www.irs.gov, to have more info. Income taxes. Now, during tax time, you will need to file a final tax return with the IRS and probably with your state tax agency as well. For partnerships, corporations, and LLCs, the federal return has a box you can check indicating that this is your final return. Sole proprietors, just stop filing Schedule C and SE with a Form 1040. What about sales taxes? If your business collected sales taxes, be sure, and this is, I cannot overemphasize this, be sure to submit the final forms and funds that are due up to the closeout date to the state office that collects your sales tax. So after paying your taxes, you can pay other debts. You likely have a lot of run-of-the-mill business debts. I'm talking about money owed to your landlord, bank, suppliers, utilities, and service providers, right? Now, after you notify those creditors of your upcoming closure, make plans to pay in full or settle. It really depends on your budget and resources, all of this business debts. If you have paid off a particular creditor or agreed to settle for less than you owe, you always want to ask for a letter indicating that your bills are paid in full. In other words, you want the creditor to acknowledge that from after paying the amount that you have agreed on, they will not chase you in court. They will not sue you for the uncollected portion of the debt. Before your last day in business, if you have employees, make plans to pay them their last paychecks. Most states require employers to give employees their final paychecks on their last day of work or within a few days. Also, some states will require businesses to pay out accrued, unused vacation days at the same time. So that you have a constellation of debts, constellation of obligations you need to account for. You need to prepare a final closure accounting for, so that you know exactly how much you will disperse in the very last, say, week or fortnight or month of the month. All right, I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweaty Q. We are still continuing our conversation here around how to close your business safely and legally. And I'm giving you a DIY step by step. This is really this can't get as easy. It can't get easier than that. I'm just breaking down for you all the steps you have to follow to close down your business safely and legally. Now, number 8, Negotiate if you cannot pay your bills. If you can pay some but not all of your debts and you are considering bankruptcy for help with the rest, be careful not to make preferential payments to creditors such as friends and relatives. Now, if you fear that you won't be able to pay all your debts, you got to understand what options you have and how to minimize the risk to your personal assets. Let's say your business is in distress. In other words, you owe a lot of money, but you can't pay. Your creditors will probably threaten legal actions against you personally. How much your creditors can collect will depend on how your business is organized. For example, sole proprietorship or corporation, whether you personally guaranteed any repayments, and whether you decide to file for bankruptcy. Now, learn which debts you are personally liable for. If you have, say, personal liability for some of your business debts, this will influence your decision whether to close your business and or file for bankruptcy. Let's talk about a little bit about the bankruptcy option here. If your business bank account is empty and you are in a lot of debt, you might be considering bankruptcy. Although it will not guarantee you'll get to keep your house or other property, it can at least give you some breathing room. And that's what you need here. If you are in financial straits, the bottom line here is that you want to have some breathing room. And you'll be able to keep the basic necessities of life. I'm talking about furniture, clothing, and so on, as well as some or all of your equity in your house and car. What about business versus personal bankruptcy? Now, if you are a sole proprietor, you can file for either Chapter 13 or Chapter 7 bankruptcy. Either can be used for personal debts or business debts. If you are a corporate shareholder, LLC owner, or partner in a partnership, and you signed personal guarantees or pledged collateral for business loans, putting your business through bankruptcy will not protect your personal property. It will not. So let's assume you want to file for personal bankruptcy, either Chapter 7 or Chapter 13. In a Chapter 7 bankruptcy, your assets, except for property that's exempt under state or federal law, can be sold to pay off your creditors. At the end, all your debts that are eligible for discharge in bankruptcy will be wiped out. In a Chapter 13 bankruptcy, you propose a repayment plan where you repay part or all of the debts over 3 to 5 years. You won't lose any property in the process, though. You will not lose any property in a Chapter 13 bankruptcy. Instead, you pay off your debt using your income. Now, we have an entire show covering Chapter 13, 7, and 11. Now, bankruptcy might help. How can it help? When you file for bankruptcy, there is something called an automatic stay. And that automatic stay immediately stops your creditors from foreclosing on your house or any other personal property. And this is pretty cool, right? Because it can buy you time, if nothing else. Now, beyond this, the type of debt you have will affect how and whether bankruptcy can help you. Bankruptcy generally wipes out the majority of unsecured debts, for example, credit card bills and loss of judgment. But secure debt are a bit different. Let's say you pledged property, such as your house or your car, as collateral for a loan. The creditor, in this case, will be entitled to take the property even if you file for bankruptcy. Although you may not have to pay back what you owe on the loan, even if it's more than your home is worth or your car is worth, you will lose your home or car. You may have the right to keep some of your equity in your home, however. Filing for Chapter 13 might be a better option if you're faced with losing property you really want to keep. In Chapter 13, you can include the debt in your repayment plan, spreading the payment over. You can spread the payments out over 5 years, 60 months. So this gives you a better chance of making good on the debt, which will allow you to keep your property. So if you are in imminent danger of losing your family's home or livelihood, you want to get in touch with a knowledgeable small business attorney with bankruptcy experience. Let's talk about number 9. As I told you, we have 10 steps, and this is number 9. You want to comply with something called bulk sale laws. Let me repeat that. You want to comply with bulk sales law. If you are planning on selling off the majority of your business inventory and your business was retail, wholesale, or manufacturing, you may need to comply with your state's bulk sales law if it exists. Only about 10 or 11 states have these laws. These laws require you to notify your creditors a specific number of days before you close your business, and in some states, to publish a notice of your impending closure in a local newspaper. Now, the laws can be tricky though. I'm not saying they're straightforward. They can be convoluted, very complex, and tricky. You may want to get help from a local small business owner in that case. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition. We are still continuing our conversation around how to close your business safely and legally. I'm giving you a tutorial here. This is a DIY step-by-step, but again, if you believe that you cannot do this yourself, or things are too complicated for you, or you don't have the will or time, please contact a small business owner with experience in business and small business closure that can probably help you out. So you need to complete the winding up. After you close up shop, a creditor will come out of the woodwork. You never know. If you have assets left or cash left from selling the asset, you should set aside some money for potential claims. Make sure the creditors who might need to get in touch with, they have your contact information so issues can be resolved efficiently without damaging your business reputation, because you might be willing to go back in business after a while. Even if your business is ending on a not so successful note, don't burn your bridges. Stuff happens. People understand that people fail sometimes and come back victors. Make sure that former employees, customers, suppliers, and other constituencies who might not need to get in touch with you they have your contact information. For instance, a former employee may need a reference. You never know when a contact can help you out in the future, right? Now, to complete the winding up, there is a checklist of things you need to do when closing your business. There are about 20 things, and I'm going to go through them very quickly here. I have talked about a few of them during this conversation we've had, but I want to give you a checklist, and you can take a note, take a piece of paper and write them down, or just listen to the show more and more over and over and over. There are 20 things. Now, although your shutdown period may be short, you should still try to give your creditors and customers clear notice of your business closure. Here's what you need to do. You want to collect outstanding accounts receivable before you notify customers you're going out of business. You want to sell off inventory. Notify your creditors. I'm talking here suppliers, lenders, service providers, and utilities. Notify your customers and deal with any remaining contractual obligations. Terminate your commercial lease. Give the landlord the required notice stated in the lease. Notify and pay your employees. Liquidate your business assets in an orderly fashion. Settle or pay your debts to the extent possible. Prioritize to protect your personal liability, money owed to your landlord, banks, suppliers, utilities, and service providers. Make your final federal and state payroll deposits. Submit final sales tax form and funds due up to the closeout date. Cancel your business credit cards and subscriptions. Comply with bulk sales laws if required. Close your business bank account and other accounts. Cancel state and county permits and licenses. File your final employment related tax form. I'm talking here about Form 940 and Form 941. File your final income tax returns. And don't forget to check the box stating that this is your final return. If you sold business assets, file Form 4797, sales of business property, or if you sell the bulk of your business asset to one buyer, you got to file IRS Form 8594, asset acquisition statements. Leave contact information with former business contacts, colleagues, and employees. Carefully distribute any remaining assets to yourself and any other owners. Dissolve your corporation or LLC or partnership. File the required forms such as certificate of dissolution. You may have to obtain a tax clearance first. This doesn't apply to sole proprietors. All right. So this is pretty much it. make sure that you're able to follow the steps. You can always contact a business attorney who can really help you, especially if he or she has been through business closings. They can help you effectively in deciding whether to file bankruptcy and guiding you through the closure process. In addition to dealing with recalcitrant landlords and other creditors, an attorney can alert you to any potential liabilities you haven't considered or any steps you might omit. Even more important, maybe seeking the advice of an accountant or a tax expert, a CPA, for instance, who can advise you on the tax consequences of selling assets, the various tax forms you will need to file, and ways to take advantage of your business losses for tax purposes, right? You can write them off. So think about it and always contact an attorney if need be. All right, folks, thank you so much for listening to us today. We really appreciate that. I will talk to you another time, but until then, stay marvelous.